Hello, everyone, and welcome back to another session on polity and constitution. I hope I'm audible as well as visible. Great, audible and visible. Let's wait for others to join and then we'll begin our discussion for the day. Okay, let's do a quick recap. In the meantime, others can keep on joining. So, first up, in the previous class, that is yesterday, we had taken up for discussion Article 15. So, beginning with this very important question, how many of you have seen Article 15? And then we, realized as to why Article 15 is important. It is a classic case of a civil right for all the citizens of the country because there are few rights 15, 16, 19, 29, and 30 which are available only to Indian citizens. So, no discrimination on the grounds of RRCSP. In the same article, we also saw through some amendments to the Indian Constitution, the Parliament provided for, or at least got the power to provide for, reservation, special provisions, quota, affirmative action, whatever you may call it, in educational institutions. Yes, there are a couple of changes made also in 2005 to the 93rd Amendment Act to overcome the PA Inamdar judgment. So, in all these cases, we saw how the government empowered itself to provide for reservation in educational institutions for scheduled caste, scheduled tribes, SEBCs, and recently in the economically weaker section category. Apart from this, one very important point with respect to Article 15, Clause 6 is that the minority educational institutions are exempted. They are exempted. Okay. Then we saw Article 16. Article 16 is a reservation in public employment, but in fact, it's equality of opportunity in public employment. No reservation on the basis of, or no discrimination on the basis of RRCSP, descent, and place of residence. So, descent and residence, domicile. So, on all these grounds, no discrimination, but we know there exists an Article 16, Clause 4, which provides for reservation in public employment. If, in the opinion of the state, that particular group, that particular community is underrepresented or inadequately represented. That's there. Then we saw the very famous Indra Sahni judgment of 1992, also sometimes called the Mandal case, because it looked into implementing the Mandal Commission. And once the Mandal Commission was implemented, it was challenged in the court. So it was reviewing the Mandal Commission's recommendations, which were implemented in the country. So those five important points, including no reservation in promotion, but we saw how in the Nagaraj case, in the Jarnail Singh case, this matter did come up once the parliament modified the constitution to provide for reservation in promotion. Finally, in the Mukesh Kumar case and earlier as well, the Supreme Court had clarified that reservation is not some fundamental right you claim, it is actually an exception to rights The right is equality, no discrimination. This is exception. Then Article 17, untouchability, the law called PCRA, Protection of Civil Rights Act, and there is one more law which is outside untouchability. It is just to prevent atrocities. So, SCST Atrocities Act, sometimes in various parts of the country referred to as the Harijan Act. We saw the provisions, the Subhash Mahajan case, all these things. Finally, completing our discussion with Article 18. What is Article 18? No titles to be given, abolition of titles, but the state, the country can give all these awards, the so called Padma awards. And yes, these awards are not titles as held by the courts in various situations. Okay, that's it. That's the last point where we had ended our discussion yesterday. Now, let's begin. Is the audio okay, guys? Is the video okay? Okay. So, let's continue now with the 5 questions for the day, starting with the very first question. Question number 1. Please mark your answer. Okay, so statement number 1, with respect to financial emergency, there is no requirement to get the proclamation of emergency approved by the parliament. Now, this is wrong actually, because the financial emergency must be approved by the parliament within 2 months, and this approval should come through a simple majority. So, one is wrong. The president may give directions for the reduction of salaries and allowances of the judges of the Supreme Court and the High Courts. Any class of persons' salary can be reduced as per directions. Any class of person. So this is correct. B2 only is the right answer. Okay, moving on to the next question. I think 30 seconds should be sufficient here. Please mark your answer. Of course, Supreme Court and High Courts are not covered under Article 12. Easy question. Most of you got this correct. Great. Moving on to the third question. Okay, clearly revisions not happening at all. So this was with respect to the amendment to the constitution, article 368, and we had a list of those federal features which require the state's ratification for amendment. So this was a part of the federal features, the lists procedure in article 368, and the high courts and the supreme court. So it is just a fact you need to remember. uh, Administration of the fifth schedule areas, all these president's rule, it's all done through simple majority, or if any change is required, that change does not need the state's consent, as in the case of president's rule, right? So 1, 2, and 4 are the right answer. You'll have to refer to the PPT for the day, that slide, it is mentioned there. So it's just a factual thing that you need to remember. Okay, moving on to the next question. Question 4. How could this be wrong? I mean, it was very easy as a question. Publishing the notification is not the power of the Indian president, is not a power of the election commission. Announcement of elections, publication of notification. Who will publish the notification? The president or the governor? So 5 is wrong. Remove 5. B, 1, 2, and 3, the right answer. Anyway, so these three were correct. One more thing, just for information, registration of political party is done by the election commission, but deregistration is done by the government of India on ECI's advice. Okay, government deregisters political parties. Registration by the uh, ECI, but deregistration by the government of India. And this is on the ECI's advice. Of course, this advice is not binding, but it would be very weird if the ECI says that please deregister and the government does not. But it is not mentioned anywhere that the advice is binding. Are we clear on this? Such a simple question. Just elimination. Now, the last question. Let's end on a nice note. Okay. Disqualification can lead to disqualification when an independent member in the legislature joins any party. Of course, independent people are not allowed to join any party. One is correct. When a member criticizes his own party outside legislature, now there is no such provision under ADL that if you criticize your party, you'll be disqualified. Maybe the party can throw you out of their own party, but still you're not disqualified from being a member if you criticize your party. So 2 is wrong. A1 only is the right answer. Okay, that's it. The 5 questions for the day done. Let's move on and discuss the topics at hand. Starting with the first topic, the constitutional bodies. Yes, the leaderboard. Look at the leaderboard. 4 people at the top: Shamil, Janvi, Kishan, and Hilo. Then we have Ankur Upadhyay, Galaxy World. Who is Galaxy World? Shovik, Geetikon, Neeraj, Archita, Surya, Twisha, Rahul, Satyaprasad, Piyush, Jasveer, Aishwarya, Meera, Bhavya, Kirtana, Abhishek. A lot of you got 4 correct. Made one mistake somewhere. Okay. Chitturi, but MP can join any party within 6 months, right? Wrong. Please revise your slides again. It is for nominated members, not independent members. Sir, please, when you make a statement, be very, very careful. Okay? Okay, let's move on now to the constitutional body. Now, we have 3 bodies: NCSC, NCST, and NCBC. So, first up, we have the National Commission for Scheduled Castes, Article 338, then for tribes, 338A, and then for backward classes, 338B. Starting with NCSC, the Commission for Scheduled Castes. Now, this particular commission was formed as a body NCSC and ST. One common commission was there, the National Commission for Scheduled Castes and Scheduled Tribes. But later on, we realized that the problems faced by the scheduled castes and the scheduled tribes are different. Also, the aspirations, expectations, etc., of both the communities are vastly different. So there was no point in having one body to cater to the needs of these two different groups. So in 2003, by amending the constitution, we bifurcated these two bodies to form two bodies, one the NCSC and the other being NCST. Okay, now what's the purpose? The purpose is to oversee the implementation of the various safeguards provided to the scheduled castes under the constitution. So, NCSC's task is what? To promote as well as to protect. Protect what? The social, educational, uh, cultural, economic interests. Protect the social interests, cultural, educational, and economic interests of which community? Of scheduled castes? Yes, of course. Also Anglo Indians. Are we clear on this? Anglo Indians. So, this NCSC, very, very important, takes care of not just scheduled castes, plus also Anglo Indians. So, the body is called NCSC only, but it also looks into the problems faced by Anglo Indians. Of course, Anglo Indian community is very small in number. Having a separate commission for them would be a very costly affair. So, NCSC has been given the additional task to also look into their conditions. This body has 5 members. We have a chairman, a vice chairman, and 3 other members who are all appointed by the president. And nothing else is mentioned in the constitution. Their salaries, allowances, etc. All the things determined by the government. Okay, that's it. NCSC. Now, what are the duties or functions performed by NCSC? First up, the duty is to investigate and monitor all the matters relating to the safeguards that are provided for the scheduled castes and to evaluate the working of such safeguards. All the matters relating to the safeguards that are mentioned for the scheduled castes. So, whatever law, whatever constitutional provision is mentioned anywhere which looks to protect the scheduled castes, the NCSC evaluates, investigates, and monitors whether those safeguards are there properly or not. Then, to inquire into specific complaints. So, if you have any problem, you can complain to NCSC and your problems will get resolved by the NCSC. Meaning, not any person, a scheduled caste person. You can approach the NCSC with your complaint of, say, harassment, of some violation of your rights, etc. And NCSC will look into it and will get the problem resolved. Okay. Then, to participate in advice in the planning process of the socio-economic development of the scheduled castes. So, evaluate the progress of the development of scheduled castes. Also, look into what steps are being taken on the socio-economic development of the scheduled caste community. Then, annual reports. So, the NCSC will submit reports to the president annually, and also at any other time if the president wants. A report can be submitted by the NCSC. Okay. Then, to make recommendations on what steps can be taken by the center or the states to effectively implement the constitutional safeguards or the legal safeguards that are there for the betterment of the scheduled caste community, and to discharge other functions that relate to the protection, that relate to the welfare, that relate to the development, that relate to the advancement of the scheduled castes, as the president may ask them to do, as the parliament may ask them to perform. Okay. Then, one more thing, the commission also takes up complaints. So, when you take up complaints, you have to, call people to be a witness. You have to ask for documents to be submitted to you. So, because of that, while investigating the matters or conducting inquiries into any complaints, the NCSC has all the powers of a civil court. We had seen this point earlier also under tribunals, that tribunals have the powers of a civil court. And I had said, if you want to know what are the powers of civil court, please refer to Article 338, Clause 8. These are the powers of a civil court. To summon, don't mug up this, it's not important. Just mentioned here, to summon and enforce attendance of any person. So you can call any person to come and attend, require the discovery and production of any documents. NCSC can ask people, organizations to submit any kind of document, receiving evidence on oath, affidavit, on a guarantee or personal guarantee that yes, the evidence is true. Then, requisition, demanding the submission of any public record, even from government offices. The NCSC can ask the government offices to submit any public record that may help in the solving of the complaint or the case. And lastly, issuing summons, communications, asking people to come and be a witness, asking people to submit documents, etc. Powers of a civil code. I'll repeat, there is absolutely no need to mug up this. Please don't. If you want to impress somebody randomly, mug up this useless information. Otherwise, not required. One very important point is this Article 338, Clause 9. Union and every state government, they shall. When I say shall, it means what? Shall refers to mandatory provision. Shall consult the NCSC on all major policy matters affecting scheduled castes. So every major policy matter that affects the scheduled castes, the union and state government must consult the commission. So that is mandatory, that is required. Clear? That's it. We are done actually with the NCSC, the functions right in front of you, all the functions. Okay. Now, as far as the NCST is concerned, NCBC is concerned, they perform exact same tasks as the NCSC. In fact, word by word, every provision you saw is mentioned in the other two articles also. So 338A and B. The only difference is in the case of SC, here it will be ST. In the case of the NCBC, it will be backward classes. That's it. That's the only difference. Otherwise, everything is exactly the same. So we are done. Just remember the articles and also remember that NCBC was a more recently formed body, formed through the 102nd Amendment Act of the year 2018, unlike the NCSC and the NCST. Clear on this, everyone? Should we proceed now? Okay. Now, let's move on and be back to our discussion on fundamental rights. Right to freedom, Article 19 to 22. Okay. Kishan, like recently, High Court declared ST for Meiti. High Court declared. High Court did not declare anything. High Court asked the state government to make recommendations to the central government for this. High courts and all cannot declare any status to anyone. Shally, sir, Article 338 also is same for them. Article 338 is meant for scheduled castes, 338A is for the scheduled tribes, and B is for the backward classes. Abhishek, Anglo-Indian provision is for under Article 338. Of course, that is under Article 338, not for 338 B and A and B. Galaxy, what happened? Nothing happened. The case is going on. Nitesh sir, how NCSC ST are related to Article 18? Article 18? They are related to equality. So since we are discussing about the reservation policy, etc., it was more appropriate to discuss those bodies which take care of the scheduled caste and scheduled tribe communities. Not Article 18 per se, but the group from 14 to 18. Since we are discussing right to equality, it was more appropriate to discuss these bodies at that point of time only. Okay. Now, right to freedom. Anshu, who is NCSC? Somebody has just woken up from sleep right now. Who is NCSC? Good question. Very good question. Moving on to this next group of rights. First up, Article 19. Article 19, let me remind you once again. Some rights are available only to the citizens. 15, 16, 19, 29, and 30. So Article 19 is available to Indian citizens only. Six different types of rights that we enjoy. All citizens shall have the right to what? 19. Clause 1, subclause A, freedom of speech and expression. So 19, clause 1, subclause A, this. Then subclause B, to assemble peaceably, meaning peacefully and without arms, to form associations or unions or cooperative societies. This phrase cooperative societies was not there originally, it was added later on. This word cooperative societies was added through the 97th Amendment Act 2011. Then, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, F has been repealed. F was the right to property. So, this earlier said, what is repealed? Any idea? What is repeal? Remove, cancelled. So, this particular provision said that you have a right to acquire, hold, and dispose of property. So every citizen earlier had a right to purchase property, right to keep property, and also right to dispose, sell property. Sadly, it is no longer a fundamental right. It has been removed from here. We'll see what exactly is the situation with property later on, hopefully tomorrow. Now, let's see the last one, G. To practice any profession or to carry on any occupation, trade, or business. Now, one more important point. All these rights that you see, these rights are available to us but are not absolute. Reasonable restrictions can be imposed on these rights. So every such right that you see here, look at just observe, every right you see here has some restriction, restriction, restriction. These two rights have a common restriction, 19(1)(d) and 19(1)(e), and again 19(1)(g), restriction. Every right has restrictions, but important, the restrictions must be reasonable. You cannot have unreasonable restrictions. Restrictions must be reasonable and they can only be implemented by a law. Restrictions cannot be imposed through executive orders. A law is required to limit, restrict the use of these fundamental rights under Article 19. Okay. 97th Amendment Act 2011. What is this 11? It won't be 1911, right? It will be 2011 only. Now, see, right is very simple. The freedom of speech and expression. That's it. I mean, yes, this freedom of speech and expression also includes some things not mentioned here. So there are some things you won't find mentioned here. So that is also a part of your freedom of speech and expression. Like what? Like the right to silence, When I ask a question in the class, you use this right a lot, the right to silence, the exact mirror opposite of the freedom of speech and expression. Then, what else? The freedom of press. This is also a part of the freedom of speech and expression. In fact, freedom of press was declared to be a part in the Ramesh Thapar case of 1950. Okay. Then, right to know of what is happening in the government. That is also a part of what? Your right to express yourself. Because the court said, if you are not informed fully, how will you truly be able to express yourself? Very, very important. Because without facts, you are just a person with your own opinion, right? And facts don't care about feelings. But sadly, here we have people who have a very strong opinion without facts. A right to know was given as a right by the court in Indira Gandhi case. Okay, the Indira Gandhi case of 1975. Later on, Supreme Court has read right to information as a part of Article 21 also in 1989. But right to know is just like right to information. Then, very interesting right, which is largely misunderstood. This is the right to access information over the internet. Right to access information over the internet. This is also a very, very important fundamental right which has been declared by the Supreme Court in one case called the Anuradha Bhasin case of 2020. So the High Court had mistakenly, I would say mistakenly only, said that the citizens have a right to internet. Now, right to internet is a very wide kind of right. You can't say right to internet. Otherwise, people will go to government and say, come on, give me 20 GB of high-speed internet daily. So, right to internet is not your fundamental right. Right to get information over the internet is your fundamental right. So, the state cannot randomly block websites. They can, but it should be logical, right? So, certain websites can be banned, internet can be banned, but it should be logical banning of the internet. Otherwise, it would prevent us from accessing information, which would prevent us from expressing ourselves correctly. So, all these are a part of Article 19(1)(a). Anyway, our main agenda is to know restrictions. What kind of restrictions? Look at the right. What's the right? Freedom of speech and expression. 3-4 words. Look at the restrictions. 8 different kind of, what are restrictions? Limitations on this right. So you have a freedom of speech and expression, but cannot cause damage to sovereignty and integrity of India, cannot cause damage to security of the state, cannot hamper friendly relation with foreign states, cannot cause public disorder, cannot impact decency, morality, contempt of court, defamation, incitement to an offense. All these things can't be done. Sovereignty and integrity of India, this was added through the 16th Amendment Act of 1963. Please tell me, Which other place? Which other place has the same phrase added with the same Amendment Act? Tell me. Don't, no, preamble is not the answer. In case you are writing preamble, it's not the answer. Kirtana, Khushi. Two people who get the right answer so far. Kishore also. Others, Sumant. This word has been added in the oath of the ministers. Do you remember? The oath of office has this word, sovereignty and integrity. Oath is under which schedule? Tell me quickly. Don't waste time. Oath is under, yes, schedule 3. Very good. Not schedule 2. Some of you are writing 2, which is wrong. 2 is for salaries and allowances. 3 is for oath or affirmation. Okay. Apart from this, words like public order, words like friendly relations with foreign states, and incitement to an offense. These things have all been added through the First Amendment Act of 1951. Okay. So these are the 8 restrictions on your freedom of speech and expression. I would expect you to remember all these 8 restrictions and also the changes in these restrictions. Yes, Vejshri. I think this is a permanent question you ask. Should I remember this also? In general, everything on the PPT must be marked up. This is very limited content. So, yes, it should. Okay. Now, coming to the restrictions, one by one, what are these restrictions? Some of them are important and some of them are easy to understand, but others may require some understanding. So, first up is this concept of incitement to an offense. Now, what is this incitement to an offense? See, Acha, let me ask you something. We have all informed, educated people here. I see sometimes some of you are, through your statements, very clearly biased. But for a lot of people, I see that they very much enjoy my sarcasm on the government or the on the opposition, etc. So I feel a general sense of vibe is that you are more okay with jokes. You're not the crazy kind. Okay, let me ask you a simple question. If today a discussion is taking place, should Jammu and Kashmir be moved out of India and be given to Pakistan? A discussion going on that Jammu and Kashmir, can we give this part to Pakistan to end our discussion on this entire issue of Jammu and Kashmir? Can this discussion take place, yes or no? Okay, some of you are saying no. I just want to ask you, those who are saying no, why not? I mean, what is the harm in discussing something? Tell me. I mean, what would go wrong if we discuss this? Any damage that it can cause to the country? Uh, yes, it's an integral part of India, but how will discussing something hamper the integrity of the country? Is the integrity so fragile that mere discussion on something can hamper the integrity. It would disintegrate the state only. Oh, amazing. Then I would like to tell all of you, don't be so angry, because you make fun of Supreme Court, that Supreme Court is useless, etc. Supreme Court has more understanding on this. Supreme Court has said on multiple occasions that discussions, however annoying they may be to an individual, discussions are always allowed. Are we clear on this? Always allowed. You can discuss any kind of idea, and they have clarified, however critical, however annoying. So some of you not really okay with even discussion. Okay, great. We'll have an amazing group of IS officers and IPS officers in future who won't even allow for discussions like this. Now, let's move on to the next step. Firstly, we discuss an idea. We discuss so many things here, right? We have discussed on the good and bad of government policies, etc. But my point now is, forget discussion. Discussion is very generic, pros and cons. What happens if we give Jammu and Kashmir to Pakistan, or what happens, or what is a problem with that? What is good with that? Okay, discussion allowed. Next step. Next step. Advocacy. What is advocate? Advocate is to preach, spread information. Now, can we start telling people, let's give Jammu and Kashmir to Pakistan? Can we start telling these things? Tell me. Advocacy, preaching, spreading this information. Now, those are saying, yes, you are getting a bit too much sentimental. Don't be so woke, also. This may not be allowed. See, advocacy is allowed. You preach the ideas, but it should not violate the constitution. So, if you are saying that let's give JNK to Pakistan, you are actually violating Article 1, because Jammu and Kashmir is an integral part of India. The pros and cons of whether a plebiscite can be held and it can be given to Pakistan is a separate thing. But telling people and preaching this information, that's a separate thing. So advocacy is allowed, but nothing can be advocated, can be preached to people which violates the constitution. So yes, it is allowed, but within the framework of the constitution. Allowed within constitutional framework. So we can have a discussion on whether parliamentary form of government is better or the presidential form of government is better. But we cannot actually start preaching the idea of replacing the parliamentary form with the presidential form. Okay. Why? Because Supreme Court has held that the parliamentary form of government is actually a part and parcel of the basic structure. We can discuss whether we can remove democracy in the country or not, but we cannot start preaching this idea, because democracy is an integral and essential feature of the Indian Constitution. Remember, discussing something is okay, but preach only those things which do not violate the Constitution. And what is not allowed is the third point: incitement to an offense, inciting people to commit an act of violence. That is called incitement to an offense. Now, this, of course, is not allowed. You cannot incite people to commit an act of violence. That sadly will not be allowed, will not be tolerated. Okay. So, and here also, when you say incitement to an offense, it will not be allowed. Definitely, it will not be allowed. But Supreme Court has put lot of checks. Steps have been taken in this regard. So there are some checks also. This is not allowed. Definitely not allowed. But not allowed only if it genuinely threatens public order. Don't curb everything. So, like, example. What can be an example here? Hate speech can be an example. Now, let me also tell you there is no definition whatsoever of hate speech in the country. There are some laws which prevent hate speech kind of things, like 295A, 505, 153A of IPC. We saw all these terms under RPA, that if you promote enmity amongst various groups, what is that? Hate speech only. Promoting enmity amongst groups, promoting enmity amongst various linguistic groups, religious groups, caste groups. So these things are not allowed. Please, if you make a statement, come on, Hindus kill all Muslims, Muslims kill all Christians, Christians kill all Jains. Now, this is all nonsense. You are inciting people to commit an act of violence. That will be a restriction on your freedom of speech and expression. Clear? So the restriction is actually incitement to an offense, which was declared by the Supreme Court also. Now comes a very, very important element. That important element is sedition. Now, sedition is not a restriction under Article 19. It is not a restriction. Not a restriction under Article 19. But since we are studying incitement to an offense, etc., sedition is a very interesting tool used by the government to harass people, to control the, no, keep a check on people's statements which can cause harm. Which can cause harm to whom? Please type your answer. Sedition means what? Anti-national activities. Yes or no? Keeping a check on anti-national statements. We've all heard this word sedition. Sedition means keeping a check on anti-national activities. Yes, no. Just type yes or no. Okay, a lot of you saying yes. Those who are saying yes, you are in for a surprise today. Sedition is a part of Section 124A of IPC, Indian Penal Code. Now, Indian Penal Code was, of course, not made by us, it was made by Britishers. But this sedition was added in 1870 to the IPC, which was made in 1860. This was added by James Stephen on the recommendation of James Stephen. But let us look at what is sedition. What is this law which most of us believe is to keep a check on anti-national activities? Let's look. Definition. Definitions are very, very important to understand what exactly the law means. Let's look at the definition. Whoever, by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into, what the hell is this? Hatred. If you bring hatred, okay, or contempt. Contempt means when you make statements which are derogatory to an individual. That's called contempt, which lowers somebody's authority, is called contempt. Or excites or attempts to excite. Excites disaffection. If you make statements, write articles which bring hatred, contempt, or disaffection towards the country. No, 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 no. Not towards the country. I said you are in for a surprise. Towards the government established by the law. Now, I'll ask you, all those who said yes, anti-national, tell me, is the country and the government, are they one and the same or are they different? Is the nation same as government or are they different? Country remains the same. Governments keep on changing. Yes or no? Today we have BJP, tomorrow we have a different party. Yesterday we had Congress. It'll keep on changing. So this is how beautiful the governments are of our day. They have molded the definition in public opinion that everybody believes that sedition, oh, anti-national, we can't remove it. Very important law. But no, the government is trying to protect sedition because sedition prevents or protects the government from any kind of speech which is critical of the government. What is the meaning of hatred? What is disaffection? What kind of words are these? There's no definition of these words. Without a proper definition, disaffection. And look at this. Look at the punishment. So normally what are punishments? Like in most laws, punishments are up to 6 months, up to 2 years, etc. Look at the punishment here. Those who do this will be punished by law, established by law, shall be punished with what? Imprisonment. Please read this. For life. You criticize the government, jailed for life. Really. To which a fine may be added, or with imprisonment which may extend to 3 years. So there are only two jail sentences, either 3 years or life sentence, not up to 3 years. How can you jail somebody for life for criticizing the government, which is an integral part of democracy? We have chosen you, right? By the people, for the people, of the people, right? So, for the people, of the people, by the people. And the governments have made us believe that, sorry, it's anti national. No, it is not anti national, it is anti government. This law protects the government. In a democracy, you are saying that if you criticize the government, if you spread disaffection, what is disaffection? Does government have a right to be loved? That please love me? No, you don't have a right to be loved. It's not possible. Okay, so it depends. If you perform well for the betterment of people, we love you through voting for you again. If you don't perform well, we will not love you and we'll show it by voting you out. So this is a problem. And that is why these laws are largely misused. These laws were made by Britishers, so they are prone to misuse. Sadly, the law has continued and everybody loves this. The ruling party will love this. That's how they keep a check on people. So the point is, I'll give an example of how this plays. Uh, a few years back, there's this very famous author, Arundhati Roy. Now, Arundhati Roy, of course, known for her book, The God of Small Things. It's a very good book, actually. Beyond that, Arundhati Roy has contributed to nothing in this country. A largely pseudo-liberal who makes statements on every international platform criticizing India, mostly uselessly. She may have a problem with the current government, but that's a personal agenda. Otherwise, she has contributed zero. There was some case pending against her of some capturing of tribal land. Anyway, that's not our concern. But she was taking part in a discussion once where they were discussing on plebiscite in Jammu and Kashmir. Can we have voting in Jammu and Kashmir where people are asked whether they want to be in India or Pakistan? It's okay. What's the harm in discussing this idea? And a case of sedition was filed against her. The court cancelled it, but it was filed. Or the very classic case of Vinod Dua. So Vinod Dua was a very popular TV presenter back in the 1990s, 2000s. And then the point was that Vinod Dua used to run a show called Zaika India Ka, like an original food vlogger. And he was very critical of BJP, very critical, and a bit too critical. Worked for the Wire, and we all know the Wire funded by where and from where the money comes into such organs. So every evening he would spit venom on the government. It's okay. Still, it's okay. It's your choice. If you don't like the government, you have every right to criticize the government. So he would make statements like the PM has used death and terror attacks to get the votes. He criticized the Prime Minister's handling of the COVID, all such things. So a case was filed against him in Himachal Pradesh by one Ajay Shyam, some local BJP leader, of what? Sedition. That you are criticizing the Prime Minister, that the PM has not handled the COVID properly. So what? Can you not criticize the government? Imagine you criticize a policy in UPSC answer and the UPSC says sedition case against this fellow. What the hell is this? It is so subjective. And this matter went to court. That should sedition be used like this? Because government will use it selectively. If I am criticizing right now the government, it may do nothing. It can also arrest me. That's a problem. The power given to the government to harass you or not harass you. They choose to, in general, not harass you. If become too big a name, they can harass you also. This is where the issue was concerned of whether we can have this draconian restriction or not. Now, governments have given a lot of justification on this. Government says that such a law is very, very useful in combating anti-national activities. Again, the same old story. Stop this nonsense. Sedition is not anti-national, it is anti-government. For how long are you going to fool the people? This anti-national story. Enough. Right? So today, that's a big problem. To all the fans of the government, you have every right to be a fan of the government. But the problem is we have to also be very neutral about it. That if things go wrong, you have no right to criticize them. Because if you do, they go crazy and they can misuse power. That's actually a harsh reality of the day. You may say there is no alternative. Yes, of course, other parties are in shambles completely, even more biased. But even the party at center has simply avoided being answerable to the people. So it is useful in combating anti-national elements. Secessionist, meaning parting ways from India. Any group which wants to break away from India. Secession. Or terrorist elements. We have to remind them that there are a lot of laws in the country which can prevent such things. Right? Then it prevents the overthrowing of elected government by illegal and violent means. Really? Overthrowing the government. If today you criticize the government that government is very bad, the prime minister is not accountable to people, they don't answer questions, are we trying to overthrow the government? At least be reasonable. They have given all these justifications to court in the parliament, overthrowing the government. Why, we already have a concept of national emergency, Article 352. If you ever feel that there is some kind of armed rebellion in the country, you can use this. What's this sedition? Harassment of individuals. Then it acts as a check against contempt of government. So the government says that can you criticize judiciary? No, right? How dare you criticize us? If judiciary deserves the respect, we also demand respect. You are framed differently. Judiciary is an appointed body, the task of which is to protect the constitution. You are an elected authority chosen by us only, and then you say, don't criticize us. It is so wrong. You cannot claim the same kind of benefit that judiciary claims. And anywhere we are finding the benefits claimed by judiciary as slightly too much. So that's also a problem. Then countering Maoist insurgency. We already have laws like Arms Act, etc., to prevent such things. So, how does the sedition counter Maoist insurgency is difficult for us to understand. So, these are justifications the government gives. Why should it go away? Why should it be repealed or removed? Number one, it goes against Article 19(1)(a). See, understand this point here. Article 19(1)(a) is what? The freedom of speech and expression. This is completely unreasonable as a restriction. Unreasonable restriction. Restrictions have to be reasonable only. And this is an unreasonable restriction. This must go away as soon as possible. Secondly, in a democracy, dissent, criticism are very essential ingredients of a very vibrant and thriving democracy, right? I mean, people, the entire opposition, they have every right to criticize the government. We also, if they do not perform the tasks properly, should we not be free to criticize the government? But we are not. It is selective. When you criticize, you have to always understand and be in this fear. What if the government uses this against us? What if the government tries to file a case against me? This fear will always be there. Then, poor conviction rate. When people are arrested, cases are filed of criticism. How many cases per 100 people arrested by the police? In how many cases does the court actually find the person guilty? Conviction rate is what is conviction rate? In how many cases of every 100 cases is the court giving conviction or finding the person guilty and the police is able to get the conviction? You'll be surprised. It can be as low as 3.3%. Out of every 100 people, 3.3% cases where the arrest was justified by the court and the court actually found the person guilty of sedition. In most cases, the court says, why have you arrested the person? Uselessly. Letting the person off. And of course, there are some states which are experts in this. In 2021, Andhra Pradesh was an expert. Maximum cases filed there. In 2020, Manipur. In 2019, Karnataka. In 2018, Jharkhand. In 2017, Assam. 2016, Haryana. 2015, Bihar. 2014, again Jharkhand. This keeps on happening. Every year, some new state finds out, oh, sedition, let's misuse it. Let's harass our people. Why? They're criticizing us. They are not loving us. Affection cannot be manufactured. I think a lot of you would know this. Love cannot be created. If somebody loves you, they will love you. However hard you try, it won't happen. It happens naturally through your behavior and actions. Okay. So, very poor conviction rate. Then, definition contains vague terms. Vague terms like hatred, disaffection, and there is no definition of these terms. And then we have plenty of alternatives available. Example, we'll see a law today only shortly called UPA. So don't worry what is UPA. We'll see this today only. Unlawful Activities Prevention Act or Article 352, National Emergency, or laws like Arms Act, or IPC, In IPC, there are other sections also, 124 to 130, 131 to 140. Various alternatives are available, in short, which can keep a check on extreme anti-national activity. So these are the reasons why it should go. In fact, countries which had sedition, UK which enforced it on us, Britain, they themselves have abolished it. New Zealand, Australia, Indonesia, such countries have removed sedition, but India carries the burden of sedition. You will be surprised to know our neighboring state, Pakistan, they follow the same kind of penal code. Recently, in the Harun Farooq case, Pakistan's High Court, the Lahore High Court, struck down the Section 124A of the Pakistan Penal Code as unconstitutional. I think Justice Shahid Karim was the judge there. Even Pakistan has cancelled it. Can you imagine? Pakistan, a failed state, that also has cancelled it. It's time for us to cancel it. So, sedition is unconstitutional. So, that's there. Now, recently, what had happened was that in the SG Bombard, this was the same case of Vinod Dua. This case went to the court, and rightfully, the court asked the government, tell me, do you want to cancel this? Tell me, please. So the government said, no, sir, please give us time to respond. My lords, give us time to respond. The Supreme Court said again, time to respond. Do you have any plans to strike down or repeal sedition? Government said, sir, time please. My lords, time please. Everything they want time, right? But this time Supreme Court said, okay, you want time to respond? Take as much time as you want. Take as much time as you want. Who is stopping you? But in the meantime, no case will be filed under sedition. No new cases to be filed under sedition, plus no coercive action will be taken in sedition cases that remain pending. So all the pending cases, government, you will not take any kind of forceful action against people like arresting them, etc. Okay? In the meantime, decide. No problem. The government can re-examine the validity and respond accordingly. So this very good excuse the government was asking for, give us more time. Supreme Court found the loophole, plugged the loophole, saying the case, the law under cold storage, you decide. Who is stopping you? A 3-judge bench, SG Umbatkere case. The judgment came last year only. And this was a very, very logical and sound judgment that this drama of finding more time, we have had enough of it. So as of now, sedition is largely put under cold storage. The law is there; it has not been cancelled, but Supreme Court's orders that nobody will be arrested, and this law will not be applicable till the government responds on what their opinion is. Now, recently, a law commission was formed. In its 279th report, that is 2023 only, this law commission has favored keeping sedition as a law. So these law commissions are made by the government, yes or no? These law commissions are extra constitutional bodies which the government creates from time to time to give some reports that it wants. So, of course, the law commission formed by the government, hand-picked members, will give a recommendation which the government wants. So, what we expect is that in future the government may use the law commission recommendation to support their argument in the court. That see, even the law commission has said that we need this sedition as a law in the country. But as of now, this topic is also under cold storage only till the Supreme Court finalizes, till the government gives a response. We may not have a question in the examination on sedition. That is sedition. Sadly, uh, thousands of people have had to face the brunt of sedition. And the worst thing that happens in a country is you punish comedians, right? Whether, I mean, I won't name any comedian because I don't see most of them as comedians. They are not funny. I mean, not truly funny. Some random jokes, it's okay. The most of the comedians who are really funny, no case against them, sadly. But the couple of people here and there who are not funny, they have been slapped with cases, making them more popular only. But that's not correct. Whether you're funny or not, I mean, the government should have the basic decency and courtesy to take the jokes. If you cannot take a joke, then nothing worse. We'll just turn out to be like the Western countries we hate so much. Okay? So that is it with respect to the sedition in the country. Okay. So we saw incitement to an offense. Now, next, defamation. So, sedition was damaging the reputation of the government. What is defamation? Defamation is damaging the reputation of individuals. That's called defamation. This is a classic example of defamation. Who are these people? I'm sure you are aware. This is Salman Bhai. Why to write it? And this person, a lot of you would have no idea, is KRK, not SRK, Kamal R Khan. So, you know very well, Salman Bhai loves to make these brain defying, physics defying kind of movies. And we have KRK. So, a couple of years back, Salman Bhai remade one more movie. This time, a South Korean movie, The Outlaws, I believe. The Outlaws is a very nice, pretty decent action movie, very popular one as well. So, he remade it, thinking Indians don't watch foreign movies. That's true for a lot of Indians. But still, Indians have largely stopped taking garbage now. So, this person, he made this movie called Radhe, if you remember. Now, Radhe, of course, was a milestone in harassing oneself. I'm not sure people did go to the theater to watch the movie. I have not seen the movie personally, so I will refrain from making comments on how good the movie was, how bad the movie was. I'll just rely on the general faith of the public that they skipped. So, of course, no, I would like to admit that I did see the trailer for 5 6 seconds. So when I saw the trailer for 5 6 seconds, I realized that no, it can cause grave damage to the brain. So I stopped immediately. No uh, offense to all the fans of Bhai, please don't come after me. This KRK, on the other hand, is a YouTuber of sorts. So he basically reviews movies. Now KRK is also an actor. He would like to call himself an actor. And KRK has been a part of some movies. He made a movie called Desh Drohi a few years back, or decades back. Desh Drohi. I mean, Desh Drohi is by far one of the worst movies ever made, especially in terms of acting. So his acting was pathetic there. But still now he reviews movies and actors, passing comments on very great actors also, right? Reviewing their acting skills, whether it is late Irfan Khan or Ranbir Kapoor, he reviews everybody. So that is why whenever in your life, if you feel demotivated, you feel like, no, life is not fair, I'm not worthy enough, please watch Deshdrohi. If this person can be happy and smiling, you have every right to be happy in life. You are deserving. Anyway, so as far as he reviewed Radhe, now in this movie Radhe, there was this actress, Disha Patni. You know Disha Patni, the actress? No idea? Oh, thumbs up. Too many. Yes, yes, I understand. Please calm down. If I ask you some article, you'll say, no, I have no idea. Disha Patni, yes, yes. Look at the enthusiasm. Please. So, Disha Patni was the actress in this movie, Radhe. Now, KRK referred to Salman Khan's age in the movie. Now, Salman Khan, as you would know, is of the same age as Mr. Amit Shah. Almost, I mean, difference of maybe 1 year or some months. Same age. So, he called Salman Khan as Daddu, Dadaji, grandfather. Daddu is a very endearing term that you use for your grandfather. He kept on calling Salman Khan as Daddu because of the age difference between Salman Khan and the actors. This caused grave damage to Salman Khan's reputation. And it was alleged that the Salman Bhai team filed a defamation case against KRK. Now, whether it is true or not, but KRK said that a case had been filed by Salman Khan. Later on, he said that Salman Khan did not file a case. But this is a classic case of defamation when you are damaging somebody's reputation. Okay, defamation. IPC section 499 talks about defamation. Or the legendary case of the most eligible bachelor of the country, the living legend, Mr. Rahul Gandhi, the perpetual youth leader. So, Mr. Rahul Gandhi had made a statement against the Modi community, or he was basically targeting Narendra Modi, but his statement was that he made some statement on why only all the Modis are thieves, with reference to Lalit Modi, with reference to Nirav Modi. So, of course, a case of defamation was filed against him, and the court gave punishment. Now, what's the definition of defamation? Any person who by spoken or written words, signs or visible gestures creates or publishes any imputation. Imputation means accusation. Mentioned here. Any accusation on any person with an intention to harm the reputation of the person. If your intention is to damage somebody's reputation, that is called defamation. Then the person making such accusations should have the knowledge or reason to believe that such accusation will damage the reputation of the person. That's called defamation. When you damage somebody's reputation, when you say, why are only Modi's thieves, or when you say Daddu trying to dance around with people half his age, etc., damaging the reputation. This is called defamation. Clear on this, everyone? This is what is defamation. Defamation case can be of two kinds. A civil case, when somebody's reputation is damaged and the person wants monetary compensation. Example, Johnny Depp, Amber Heard. Remember this Johnny Depp Amber Heard story? In this Johnny Depp Amber Heard case, Amber Heard had made allegations that Johnny Depp had abused her, domestic violence, etc., which resulted in a loss of lot of money, franchisee for the star. He lost a lot of movies where he could have been a part of. He lost money. So he went to the court to file a defamation case seeking compensation, that because of my damage to reputation, I need monetary compensation. Imagine Salman Khan goes to court and says, see, because he is calling me Daddu, now no young actress wants to work with me because they respect me now. They touch my feet first. They are not willing to dance with me. They're all calling me Daddu, right? So no one is offering me movies. I'm only getting father's role to play, all these things. So this was a problem, that my monetary loss has happened because of damage to reputation. So please, this other person, pay me, compensate me with money. That is called civil defamation. But what is more grave and dangerous is criminal defamation. When you say, no, no, I don't want money, you send the person to jail. So you file a criminal case where the punishment can be a jail sentence of up to 2 years. Now, this is the jail punishment that has been given to Mr. Rahul Gandhi. He has been given maximum jail punishment. Now, this is too much here. I mean, yes, you can make fun of the person, but this is too much. Giving somebody maximum jail sentence is not justified, right? Even if you are a hater of the person, you would have to agree that it seems very biased, sadly, right? 2 years. All our politicians make such statements. They have made worse statements than this. Nobody is being punished. So that's it. So 2 years of jail or fine or both. This is called defamation. Clear on this, everyone? Now, this criminal aspect of defamation has been upheld by the court also. So in 2016, a case was filed by Subramaniam Swamy that criminal defamation should be removed. Why to send somebody to jail for making fun of you? But Supreme Court said no, no. It is very important because it is a duty of the government to protect the citizens. It's the duty of the government to protect the citizens, protect the people of this country from damage to their reputation. The duty to protect the reputation of all the citizens. Of all the duties of the government, the court feels that protecting the reputation is such an important duty. But anyway, the criminal part still remains, and this is what is called defamation, the punishment of which is mentioned under IPC section 500. Defamation. Okay. Now, what can be the possible issues on defamation? See, number one, when you go to court and claim that my reputation has been damaged, worth 50 crore rupees. Imagine somebody makes fun of you, and then you go to court saying, court, please ask him to pay me 20 crore rupees. My 20 crore rupees worth of reputation has been damaged. Maybe in your Google Pay account there are 17 rupees only, but you will claim my reputation is worth crores of rupees. Pay me money. So the point is that exaggerated valuation. Calculation is biased. May be biased. How can you calculate the exact amount, right, of worth of damage that happened to your reputation? Difficult. So everybody would want to, uh, file a case of exaggerated valuation. Then multiple cases filed simultaneously. So anybody can file a case on defamation. Okay. Let's say you are sitting in Delhi and you are writing an article on against Narendra Modi or against Rahul Gandhi. Now the fans of Mr. Modi and Mr. Gandhi are spread all across the country. Somebody in Jammu and Kashmir reads the article. Somebody in Lucknow reads the article. Somebody in Patna reads the article. Somebody in Guwahati reads the article. Somebody in Gangtok reads the article. Somebody in Dimapur reads the article. Somebody in Jaipur reads the article. Somebody in Chennai reads the article. Bangalore, Andaman Nicobar, Lakshadweep, Kanyakumari, all across the country. People read articles and file case, a criminal case in the local court. Like what happened for Nupur Sharma. Now, the problem is people have filed a criminal case all across the country against you. You have to hire a lawyer, go to court, tell all these courts that see it's the same case. Please transfer the case. Maybe your case will be transferred to Delhi. But the harassment begins. You have to travel to multiple places to convince the court that it's the same case. So we say that your Bharat Darshan begins without even clearing UPSC, right? So this is very dangerous. It can result in possible harassment of people, right? Possible harassment. Next time when you write an article, you will think hundreds of times before making any kind of statement against Rahul Gandhi or Narendra Modi. So that's the problem. Number three, who files a case under defamation? So many of you sitting here, your friends make fun of you. In fact, amongst males, that's a term of endearment. Making fun is what is endearment, the love. So most of your friends show love towards you by calling you names only. The harsher the names, the more they love you. Let's say you post some kind of a photograph on Instagram. You have purchased some new uh, shirt, dress, etc., and you post a photograph on Instagram expecting some likes. But you know how people are. They may start writing, looking stupid, looking silly, looking like a monkey. You read the comments, feel very bad about it. What do? Nothing. You simply shut down the computer, go out, cry, come back after 2 days, start the same drama, again post new photographs. You don't go to court and file a case that somebody is calling me thin, fat, short, tall. Imagine our school days, right? So we have realized that this kind of defamation case is exploited only by the privileged elite people. Only they keep on filing the cases. Okay, so this was largely exploited by the privileged groups, right? Primarily by the privileged groups. And common man rarely files a case in defamation. Lastly, public resources are being used to settle what is actually a private dispute. What are public resources? Public resource of police, public resource of judiciary. Now, in a country where deaths, rapes, such things, matters are pending in the court, you go to the police, right? When the police is trying to find out the murder weapon of a double murder, etc., that and you go to court, police saying, police, register my complaint. That person has called me thin or fat. I mean, come on, be realistic. Come on. In a country with lack of resources, you want the police to leave the work aside and then chase after a person who has just made fun of you. I think we can do better than this. So the problem is that the criminal defamation is the real problem here. If it's civil, no problem. Criminal one is very harsh. Jail sentence making fun of somebody is a bit too harsh. Nevertheless, it has been upheld by the court in 2016. So any question on this, we know very well that the court has upheld it. What can we do? That is defamation. Okay. So next one is contempt of court. Now, what is contempt of court? Contempt of court comes from a law, as you know very well, that restrictions can be made through a law only. So, contempt of court through a law, this law made by Parliament. Now, what is contempt of court? There are two kinds. Number one, civil contempt of court. If the court gives a judgment, an order, and you deliberately, willfully, knowingly disobey the lawful order of the court, that would be called a civil contempt of court. If you disobey the court's order, but if you make statements which scandalize, what is scandalize? Shocks the court, horrifies the court. That's the meaning of the word scandalize. Okay? Which shocks the court, which horrifies the court. It attacks the dignity, it lowers the authority, it obstructs the course of justice. Then that's called criminal contempt of court. Now, of course, these words are not defined. What is meant by attacking the dignity? What is meant by lowering the authority? Such vague words. What can we do? Sadly. But yes. Now, one more thing. Please understand, if you criticize the court fairly, that will not be contempt. And accurate and fair reporting of the court proceedings is not called contempt. Two things. Accurate reporting of court proceedings plus fair criticism of judicial acts. This is not contempt. The law itself says so. And if you have facts to back your allegations, that's not contempt. So if I make a statement that judiciary is not representative, and I give you examples of how women have not been represented, how SCs, STs have not been represented, then that would not be called contempt, because I am giving facts to support my allegation. But if I say judges are corrupt and I give no facts, I just say, no, yeah, I know, it's a perception, right? Then that is wrong. That could be contempt. So, what is the punishment? The punishment is imprisonment of maximum 6 months, fine of 2000 maximum, or both. And why do we have this concept of contempt? The concept of contempt is why? Because we need to preserve the judicial independence. If anybody can start criticizing judiciary randomly, then how will the judiciary be able to independently perform the functions? Right? And secondly, to also uphold the dignity, uphold the respect for the courts. Clear on this? Now, who can file a case? Who can file a case of contempt? Supreme Court or High Courts? Suo moto. What is the meaning of suo moto? Tell me. On its own. So, Supreme Court and High Courts, because they are court of records, they can themselves file a case. Supreme Court itself. Second, can people file a case? Yes, we can also file a case, but permission of Attorney General or Solicitor General or Advocate General is required. Okay, so if we want to file a case, then we need to get the permission of the Attorney General or Solicitor General or Advocate General. They will allow that, okay, approved, then only we can file a case. Otherwise, we cannot. That is with respect to contempt of court. Clear? Publishing of accurate reportings basically refers to the court proceedings. So if I publish the judgment of the court accurately, then that's not contempt. Okay, that is the meaning of it. A very interesting case of contempt was this lawyer Prashant Bhushan. Now, Prashant Bhushan is a very good lawyer in the sense that he takes up a lot of matters for the poor, deprived section of the society. So, in that sense, he's a very popular lawyer. But along with that, he also makes some random and loose remarks, which are not backed by facts, sadly. So, a few couple of years back, uh, there was a case where S.A. Bobde was the Chief Justice of India. Now, S.A. Bobde had gone to Nagpur to attend some personal ceremony, and he saw a bike somewhere, maybe a fan of bikes. He sat on the bike and got photographed. That bike was a very special bike. It was a Harley Davidson. The Harley Davidson has a division in their company called the Custom Vehicle Operation Division, which every year manufactures one custom bike that is a bike of the year. The 2020 edition, 2021 edition. It's called the Harley Davidson CVO, Custom Vehicle Operation, that year's edition. So that bike was a 50 lakh rupees bike, a 2020 edition of the Harley Davidson. So he sat on the bike. Next day, Prashant Bhushan tweets, "Look at the CGI without a mask sitting on the bike of a BJP leader in Nagpur. The bike by chance belonged to some BJP person." Right? So, what do you mean by this? What is his allegation? That is he hands in glove with BJP? No facts, nothing. So, the court did not like this. Case was filed. He was asked initially, please apologize. He refused to apologize. So, when he refused to apologize, the court finally, because the court also knew that this person, uh, if you punish him, it will also impact the cases he is filing in the court to protect the rights of the poor, needy people. So, keeping in mind his personal behavior outside the court, also helpful nature in society, the contribution, the court said, okay, but you are wrong. We are imposing a fine of 1 rupee on you, a token fine. Why? Because you are wrong. I mean, Prashant Bhushan refused to pay that fine also. Say, I will not pay any fine. Then some other lawyer, Rajiv Dhawan, said, okay, don't worry, I am paying fine on your behalf. All these dramas keep on happening, but this is what is contempt of court. Now, what's the problem with contempt of court? Vague terminology, horrifying the court, lowering the dignity, authority, attacking the dignity, obstructing the course of justice. What are all these things? How do we know? If you are sitting in the court and when the judge gives a judgment, you say, come on, great judgments are amazing, genius. You are clapping, throwing paper balls on the judge. That could be contempt. But what if your phone rings in the court? Will that be a contempt of court? We don't know. So it is very subjective for the judge. And a very big problem is that it violates the very first principle of natural justice. So, what is the principle of natural justice? The first one, nema causa in judex sua. No one shall be a judge in their own case. Are you not being a judge in your own case? Who is filing the case? A contempt case is filed by the judge. Who decides whether you are guilty or not? The judge. Who imposes penalty or punishment? The same judge. So you play the judge, jury, executioner, everything in one only. So this is what is contempt of court. In 1978, in one Mulgaonkar case, the court did give some suggestions, recommendations to itself and the high courts. That see, courts, please understand, economic use of contempt is desirable. Don't misuse contempt. Use it in an economic fashion. Don't overuse it. Everything contempt. Somebody smiling, contempt of court. Somebody sitting with 2, 3 buttons open, contempt of court. No. A lot of people who come to court, they may not have an understanding of how the court functions, the rules and regulations. So relax. As the song goes, calm down. And there should be harmony between free criticism and judicial independence. So, yes, judicial independence is very important, it is required, but there should be a balance. We also need to allow free and fair criticism, and media should be given a free play. Within reasonable limits, media should be allowed to look, be critical of the judgments, evaluate the judgments. And lastly, judges, don't be hypersensitive. It is okay, no problem. It is okay. If somebody does not like, uh, or if somebody reacts slightly differently, don't be hypersensitive. Don't go on and punish the person. Jail 6 months. Mobile phone rang twice. Jail 6 months. This should not be done. That's it. Contempt of Court Act 1971. Okay. Solve this question came in 2022. Okay. So a lot of you got this correct. The Constitution of India defines. There is no definition in the Constitution. Is there any definition mentioned? The law tries to define what is contempt, civil and criminal contempt. So this is wrong. And in general, we have found that such statements are usually wrong because the Constitution rarely defines anything. So remove this, remove this. Now 1 and 2 have to be correct. So these two have to be correct. Let's check for 4. In India, the parliament is vested with the powers to make laws on contempt of court, of course, because the contempt of court power lies with the Supreme Court and High Courts. So the parliament. 4 is correct. B is the right answer. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act was passed. This is an impossible statement to mark and to know also. So many laws, so many committees. But we did not need to know this information. This was automatically correct. The Constitution of India empowers the Supreme Court and High Courts to punish for contempt. Now, see, the Constitution never directly empowers the courts. Actually, it does it only through the fact that they are called court of records. Since they are court of records, this automatically means that they can also issue for punish for contempt. So here the statement is correct. So 1, 2, and 4. How is the fourth statement correct? In India, the parliament is vested with the powers to make laws on contempt of court. Who else will make laws? Tell me. Can the states make laws on contempt of court? Is it possible for states to make laws for powers of High Court and Supreme Court? High Courts and Supreme Court's powers are regulated by the parliament. So, of course, 4 is correct. That means B, 1, 2, and 4 being the right answer. That's it. Let's take a break. Be back at 8:05. Break, please. Okay, so now the next right was the right to assemble peaceably and without arms, of course. And this right has restrictions. Two restrictions: sovereignty and integrity of India, and public order. So, of course, you have a right to assemble as a mark of protest, etc. But right to assemble does not mean right to assemble anywhere. That's there. Of you can't say I want to assemble in my neighbor's house. Not possible. And right to assemble does not include right to strike. Why? Because right to strike is not a fundamental right. Right to strike is a statutory right. Right to strike comes from a law called Industrial Disputes Act of 1947. Their section 2 of the law defines what is strike. So any kind of recognition that comes to strike comes from this law, not the constitution. One more thing, after what happened in the Shaheen Bagh situation, I think now we have a better understanding of what happened in Shaheen Bagh, the protest, and the reason for the protest because of that chronology of CAA, NPR, NRC thing, and largely misinformation. When it comes to the protest, Supreme Court in the Amit Sahni case said that right to assemble or protest does not mean right to indefinite protest. So you have no right to protest indefinitely or even occupy public space indefinitely. Occupy public space indefinitely. This was Supreme Court in the Amit Sahni case 2020. Okay, that's it. Clear? Protest is to raise your concerns against something not done by the government. Strike is to raise concerns on demands you want to be met. They are two different things. I feel I sometimes need to explain English also here. So, protest and strike are different in the sense that strike wants us to, or strike has a purpose of meeting our demands, and protest is raising the concerns, showcasing the failure or shortcomings of the government. Different. Okay. Now, how is this right curtailed through laws? Indian Police Act, classic example. If you want to protest, etc., take out a procession, rally, you have to always take the permission of the police. Without their permission, no such rally or protest or procession is allowed. Number two, the Prevention of Seditious Meetings Act. So sometimes your protests, which are targeted against the government, can be prevented through this law. Or Section 144 of CRPC, Code of Criminal Procedure, or 141 IPC. They talk about, I think you must have heard this word, unlawful assembly. So, what is the meaning of unlawful assembly? Unlawful assembly refers to any group of people, five or more people, who gather at a place. 5 or more people is, or it can be called an unlawful assembly if the SDM or the DM or any other officer authorized by the state government issues an order in this regard, that to maintain security, etc., or public order. Right now, unlawful assembly, meaning if 5 or more people gather anywhere, that is unlawful, you can also be arrested. So this order can be issued by a district magistrate, by a subdivisional magistrate, or also by any concerned officer that the state government appoints. But this kind of order cannot be issued for more than 2 months. Yes, it can be done for additional 6 months, but that will come through government's notification. A DM can issue this for maximum 2 months. So in future, you can issue this order and prevent any kind of assembly, have a curfew of kind of situation in your area. Next, subclause C, that is the right to form associations, form unions, form cooperative societies. So your right to form associations includes, or should not hamper, the sovereignty, integrity of India, public order, morality. Morality, would, you can think of morality in the sense that your right to form any association uh, does not include right to form brothels. So in India, prostitution, selling sex for money, if an individual wants to sell sex for money, there is no problem in that. I mean, there is no law which prevents that. But if you want to run that as a group activity, meaning a proper organization, an association, few people running, you hire a pimp, right, an agent of sorts, that becomes an association or an activity. So that may be curtailed because you have no right to run a brothel or such places. Okay, are we clear? So whenever you see any such area, you will find that there are two reasons why the police does not interfere. Number one, they can simply claim, I am working here as an individual. There is no agent I have hired. Number two, large groups of people are involved. So if you arrest them, displace them, there could be some human rights issue. So sometimes, we knowingly ignore the blatant abuse of law because what else can be done? But largely in such areas, so-called the red light areas, people claim that this is no racket going on. I am an individual working individually. I don't care about others. That's how they try to defend themselves. But yes, such things are not allowed, and it's a very gray area because individuals allowed, groups not allowed, and laws are also not imposed very strictly in these areas. That's there. Okay, that's it, Vivek. What kind of questions they are, Vivek? Sir, reading newspaper in court, is it contempt of court? What is the sense of these kind of questions you ask here? Ask yourself, just because you have a forum to type. If this was an offline class, would you ask all these kind of questions in the class? Sir, brothels mean what? Google search dictionary, sir. Very simple. Brothels are places where sex is sold. Have the decency and courtesy also to maintain the respect for the forum. Future civil servants, extremely unlikely if this behavior continues. Anyway, we have a right to form associations. Yes or no? Do we have the right to form terrorist association? You may claim that I have been told I can form association, but can I form a terrorist association? Of course not. It can hamper the sovereignty and integrity of India. So, before you have such plans, there is already a law in the country, UPA, Unlawful Activities Prevention Act, 1967. Now, this law is applicable on both Indians and foreigners. Let me clarify. Just because Article 19 is meant for only citizens does not mean that this law is not meant for foreigners. both citizens and foreigners, because largely terrorists in our country are foreigners. Yes, they also get some support of the locals, but largely foreigners. Now, this law has its origin. If I remind you, you would remember. There is a law called, there used to be a law called Anarchical and Revolutionary Crimes Act, 1990. No? Rowlatt Act, 1990. Rowlatt Act. Rowlatt Act's original name was this only, Anarchical and Revolutionary Crimes Act. So UPA traces its lineage from this law, the draconian law. And for the first time, uh, it was used in the CRPC, the CRPC amendment done in 1908, the old CRPC, not the new one. Later on in 1967, a proper law was made in the country, amended so many times, right? Especially in 2004, when this law called POTA was a dangerous law, Prevention of Terrorism Act activities, POTA. When POTA was repealed, the POTA provisions were added in UPA. UPA is a very dangerous law. So, UPA's purpose is to prevent certain unlawful activities of individuals and associations and to also deal with terrorist activities. That's the purpose of UPA. Now, under UPA, not only a group, but even an individual can be declared a terrorist. You can be called a terrorist by the government. The government can declare you or me a terrorist. Now, if you are declared a terrorist, what happens? Nothing happens. It's okay. The government can declare you terrorist and still may not arrest you. They may do nothing. You are free to roam around here and there as a terrorist. So this is a very unique and weird kind of situation where if you act over smart, criticize the government, bad policies, no governance, terrorist, home ministry, notification, terrorist. Possible. Then the punishment under UPA is what? Minimum 5 years to maximum death sentence, life imprisonment. Of course, fine is also there. Death sentence will be given only if your action has resulted in the death of somebody. Then death sentence. In fact, if you are a member of an unlawful association, if you are a member of an unlawful association, even if you have not performed any activity, let's say you are a part of a WhatsApp group, and the WhatsApp group, some members have committed some crime, and the WhatsApp group is called unlawful association, and you are a member there, that is also declared to be an offense. Just recently, Arup Bhuyan case, Supreme Court said this, that being a member of an unlawful organization is also an offense. So please, before you become a member of any organization, make sure that that organization is legal, it is not unlawful. Now, as I said, that this law is meant for terrorists. So this law also defines terrorists. Who is a terrorist? Now, there is no categorical definition if you read it. It's so vague. Any act which, what's a terrorist activity? Any act which threatens or is likely to threaten the unity, integrity, security, including economic security of the country. If your act threatens that, or act which is likely to threaten all this, then that can be called a terrorist activity. Number two, if your act strikes terror or is likely to strike terror using bombs, explosives, other examples included here are dynamites, then explosive, inflammables, right? You mentioned explosives, inflammables. What are inflammables? Any idea? Science, class 8, ninth. Any idea? Inflammables. or any other means of whatever nature. Means of whatever nature. Yes, inflammables are those things that catch fire easily. That is called inflammables. Simple. Oh, which are prone to intense ignition. Flames can be caused. Rumors, non combustible substances, which can catch fire easily. Simple. Okay. Uh, or any other means of whatever nature. Actually, one more thing. Under this law, what is a terrorist activity? Other things. If you compel the government by kidnapping, let's say you hijack a plane, you hijack a bank, etc., and compel the government, meet my demands, give me the UPSC prelims paper beforehand only. That can be called a terrorist activity. What else will an aspirant demand? You won't demand money and all. You would say, show me the GS 1, 2, 3, 4 papers. So that can be a terrorist activity. Don't try this. Please study. There's no alternative like this. If you try this, then you are a terrorist only. Then what's the point? Or very interesting. So some of you will clear the examination, will become IAS, IPS officers, various kinds of officers. In future, if somebody tries to causes or attempts to cause death of a public functionary, if you are killed by some person and you are a public functionary, then the person who has killed you will also be declared a terrorist, and this is called a terrorist activity. So when you die right now, no value. But if you die in future as an IAS officer, you can die in peace, knowing very well that the person who has killed you will be declared a terrorist. Clear? This is today's motivation. That clear the exam, and when the person kills you, terrorist declaration. What to do? Motivation is very important on a daily basis. So we have to create motivations. So this is the definition of a terrorist activity. Okay. Now comes the problem with UPA. UPA is a very largely a stupid law because UPA is simply misused. The government has completely diluted the distinction between political dissent and criminal activity. Are we clear on this? For example, the definition of terrorist, very vague. Words like likely to cause or words like any other means. What is the meaning of any other means? You are saying dynamite, chemical weapons, inflammables, and suddenly say any other means. I'll give you an example. If your mom has asked you put down the phone, she has said twice, thrice, and you're not putting down the phone. Then comes a slipper flying on your face. Let's read. It's an act which is likely to strike terror in your mind using any other means of whatever nature which can cause death or damage to property. Will we now go to court and say, mother is a terrorist using slippers, striking terror in my mind? So, loose words. The definition is slightly vague. Are we clear on this? So, this is the beauty of the vague definition. It is prone to misuse. Unlawful Activities Prevention Act. Somebody was asking what is UPA. This is UPA, Unlawful Activities Prevention Act, the topic we are studying. Then difficulty in getting bail. Also, let me clarify, Supreme Court has said time and again that bail is a norm, right? Bail should be granted. Jail is an exception. But under UPA, bail becomes a exception. Jail is a norm. if bail is denied, if the charges, allegations prima facie seem to be true, if allegations appear to be true, if to the magistrate, the judicial magistrate, he feels that the allegations are seemingly true, prima facie they are true, on the face of it they are true, then no bail for you. And even beyond that, to get a bail, you need to get the opinion of the public prosecutor, government's lawyer, the other side's lawyer. So this is very challenging. Secondly, whenever anybody is arrested, the police is given some time to file a charge sheet. What is a charge sheet? See, when you break a law, you break multiple laws, or you break one law. Which law have you broken? What are the allegations against you? What are the charges against you? Allegations or charges are mentioned in a piece of paper that is sent to court with a complaint. That's a complaint. We don't complain to police. That's a misconception. We inform the police. Complaint can only be given to that authority which has the power to punish. Police cannot punish. The courts can punish. So the police will take your information, prepare a list of charges, allegations, and go to court and complain. So that's a charge sheet. Normally, charge sheet should be filed in 90 days. Here, charge sheet filing time is double, 180 days. For 6 months, you can be put behind the bars, wait, and the police will not even go and complain in the court. 6 months waiting time. Okay. Then it also undermines federalism because the UPA is implemented by NIA, the National Investigating Agency, and we also have the state police. Conflict between the state police and NIA, National Investigating Agency. It's a central agency. Okay. Here also, one more problem, very, very poor conviction rate. To tell you frankly, in the last 10 years, there have been roughly around 10,000 plus arrests, of which the conviction rate is just 2%. Almost 2% conviction rate. In the last 3 years, that is 2016 to 2019, the conviction rate was 2.2%. Meaning, out of around 10,552 people arrested between 2014 and 2020, how many were punished? 253. Majority, 98% people were found not guilty by the court. And 5% cases only actually are complete. Rest are all pending. 60% cases have not even gone to court for trial. Only 40% cases have gone to trial. And only 4.5% cases have been completed. Such is a lethargy. It is just to harass the people. Conviction rate refers to the rate of punishment imposed by the court per 100 people that the police files the case against. So when the police files a case against a person, then the police feels you are guilty. If the court finds you guilty, then the police has won. It was a right conviction. It was a right arrest. If the police files a case against you and the court does not find you guilty, that's a failure of the police. They've arrested the wrong person, right? So conviction rate is where you can see the success rate. Clear? So this is with respect to the conviction rate. Different from TADA. TADA was a law which was used under preventive detention. We'll study TADA. We won't study TADA, but I'll tell you what is preventive detention under Article 22. That was TADA. This is after a crime has been committed, a regular normal law. TADA was a preventive detention law, arresting people even before crime is committed. Uh, I'll explain the second and third point again, or, and fourth point also. Even though I explained, but of course I need to, because or else why will you waste time in uh, seeing the video again, right? Because you have busy other things to do in life. Second point: bail is normally not given to people under UPA. Okay, it is very difficult to get a bail because firstly you need the approval, the opinion of the other lawyer. Secondly, the judge will deny bail if he or she feels that the allegations seem to be true, which is a very vague criteria. Number three, normally in other cases, the police gets 90 days of time to file your case in the court because that's where the case begins. So within those 90 days, you are out on bail or in jail suffering, and then the case starts in the court. And only then can the court declare a punishment or find you not guilty. So case needs to be filed in the court at the earliest. In the case of UPA, the time for filing a case is double, 180 days. Plus you are not getting a bail. So for 180 days you will be in jail waiting for the police to file a case against you. And later on the court finds you not guilty. Is it not harassment? Arbitrary powers. For 6 months you are in jail and finally end up what? End up with a case where the police does not find, the court does not find you guilty because conviction rate is very low. So gives arbitrary powers to state to randomly harass people. Then undermines federalism. So when it comes to federalism, a very important element is that the state's power should be there intact. Here, public order comes under state list. Yes or no? But if there is any act of terrorism, NIA is a central national investigating agency. It's a central body, central government's body. It will come and take over the case, undermining the state government's power to take up such matters. So public order and policing are state functions, but center is performing these functions because of NIA's overriding powers. So it also undermines federalism. Center tries to assert its dominance over the state list topic. Clear? So these are issues with UPA. Aishwarya, uh, what to do? We have to mug up those classes, watch the live videos available again and again. If you have skipped some, this is a statement for all of you guys. Firstly, ask these questions towards the end of the class or the beginning of the class. Secondly, if you have skipped on any kind of class because of certain obligations, family functions, studies, examination in college, etc., live recordings are available. Watch those videos, take some time out, involve that in your syllabus, in your daily timetable to watch those videos. What else is a alternative? No alternative, right? That should be done. These are the issues concerning UPA. Now, two other rights and their restriction: 191D, 191E. They have the same restriction: right to move freely and right to settle anywhere, interest of general public, and protecting the interest of scheduled tribes. So we know very well that we have a right to settle anywhere. That is the concept of no single citizenship and one domicile. So right to reside anywhere, right to settle anywhere, right to move anywhere freely. Yes or no? 191D, 191E. And both have the exact same restriction. So yes, you have a right to move anywhere, but it should not violate the interest of general public. That's it. Or it should not violate the interest of scheduled tribes. Tell me, tell me examples of restrictions that are imposed on your right to free movement and settle anywhere. I will write two examples. You keep on writing more examples. One is the epidemic Diseases Act. Then you have the Disaster Management Act. What else? Okay, very good. Schedule 5 areas, Schedule 6 areas, the concept of inner line permit, then border areas. What else? Then, of course, if you are suffering from any contagious disease, your right to movement can be curtailed. Then IPC provides for provisions. Then there are a lot of laws in the states called Gunda Act. Under these Gunda Acts, you will not be allowed to settle or reside anywhere. You can be thrown out. Then you have, of course, what else? The Supreme Court or High Court orders. They can also order you to move out of a state. Yes, border areas, strategic areas, we can mention them here only. Military cantonments, all these areas, all included. So these are plenty of examples of how your rights can be restricted. Here also, same as previous slide, exactly the same. Then one more thing, you have various forest acts in various states which will prevent you from using the forests to settle. Okay, that's it. We have discussed these two separately under Schedule 5 and 6 areas. This we have discussed under CAA. I won't write this because it will create confusion. I just explained that inner line permit was discussed under Citizenship Amendment Act. You can refer to the topic and revise accordingly. Lastly, 19(1)(g), right to practice any profession or to carry on any occupation, trade, or business. Okay. So you have a right to POTB, profession, occupation, trade, business, full right to all such activities. But there's a small problem. The problem is this, that your right can be restricted. How can it be restricted? This right can be restricted simply by providing for a professional or a technical qualification. Yes or no? If today you say that I want to conduct open heart surgeries, I just want to do it. Are you a doctor? No, no, I'm not a doctor, but I think I can do it. And you open a shop in front of a house. Say, come on, guys, heart surgeries, 20 rupees only, 20 rupees only. Will that be allowed? I mean, for certain things, professional or technical qualifications may be required. So that can be a limitation. Secondly, if you claim that I have a right to practice any kind of profession, any kind of occupation, any kind of trade business, okay, don't be excited. You can claim I want to build my own missiles, my own Chandrayaan, my own bombs. The government can say sorry. Tomorrow you will say IPC, Indian Penal Code, CRPC, all these laws. I want to start my own police service and implement these laws in the country. You call your friends and say, come on, we are the new police. This is my police service, and start arresting people randomly. Now, again, there can be certain monopoly over a trade, over a business, over an industry, over a service, excluding citizens. So, government can exclude you and say, please sit down. Don't start your own police service. If you want, clear the exam, join the police service. We have our own police service. So, these things can be done. That's it. We are done with Article 19. Look at this question asked in the examination 2022 last year. Right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. Yes or no? Rights, are they absolute? Firstly, of course not. And then the right to movement and residence, that is not absolute. So many restrictions are there on these rights. We have seen examples of so many restrictions on these rights. Mention those examples. Mention why rights are not absolute. Limitations have been placed, but those limitations have to be reasonable through a law. All these, explain some of them. A 10 marker. Simple. That's why he said, please mug up all the restrictions. It's important to remember the restrictions imposed on fundamental rights. It is more likely that the question will be asked on restrictions. Nirbhay, I am just addressing the exact same point that you have asked. Sir, do we have to remember the restrictions? Exactly. Yes, sir, we have to remember the restrictions. I am showing a question which asks restrictions. Kirti, sir, do restrictions more important? Yes, restrictions are more for examination. And in general also, restrictions are very important. Knowing rights is not sufficient. Knowing the limitations of rights is more important. So, well, this question related to issue that people acquired. No, no, Sachin. That is far-fetched. It had got no relationship to that. No, Kishan, we need not remember IPC. Only those sections that I have mentioned in the slides are sufficient. Don't mug up IPC. It's of no importance. Now coming to, yes, Lucky, it depends on article subsection. Firstly, please change your statement. Articles don't have sections in our country. In our country, articles have clauses. Don't say subsection. Say subclause. So yes, it may be important. Article 19, clause 1, subclause A is very important. It gives you the fundamental right to speech and expression. So sometimes a subclause also needs to be remembered. It will depend on what that context is. Now, next is Article 20. Very simple, three provisions. Number one, no ex post facto law, no double jeopardy, no self incrimination. What is this no ex post facto law? What is that? No ex post facto law. This means that no person shall be convicted of any offense except for violation of a law in force at the time you committed the crime. Are we clear? This means that you will not be punished from back date. Clear? This is available only for criminal cases, criminal laws. So any criminal law cannot be modified from back date. Retrospective effect. What's the meaning of this retrospectively? For example, a very classic example of this is the Nirbhaya case, actually. Now think of this Nirbhaya case. I hope you all know the Nirbhaya case of 2012. Sometimes humanity is put to shame by the acts of our fellow human beings. One such example was Nirbhaya case. Now, In this case, of course, of the 5 people who were convicted, some of them were hanged. One person committed suicide. The other one was a juvenile, a minor. Yes or no? Minor, under 18. So people under 18 are not punished in the regular procedures in our country. But it was also seen that this minor, or I mean, we don't have any way to ascertain that, but based on the other people's statements also, which can't be relied upon, still they said that the minor was equally involved in the gruesome activity. But because the law says that if you're under 18, you will be treated in a juvenile court only, which does not give death sentence or such punishments, so this minor escaped the harsh punishment. But this brought us to have this thinking also, that kids between 16 to 18, can they be treated as adults, at least based on circumstances? So a committee was formed under Justice J.S. Verma. This committee gave a recommendation that yes, kids between 16 to 18 may be treated as adults. So a Juvenile Justice Board, JJB, these things are not important. I'm just explaining an example. The Juvenile Justice Board, this Juvenile Justice Board will look into whether any kid between 16 to 18 was mature enough to understand the repercussions of his action or her action or not. If the Juvenile Justice Board treats you or considers you as an adult, then the court will treat you as an adult, even if you are under 18. But this change was made in 2015. The crime was committed in 2012 when the minor was 17 years old. Now, can we apply this law to the minor? Tell me, can we apply this law to the minor now in 2015? No, we cannot. And we should not also. See, because if you start applying laws from back date, it is prone to misuse by the state, by the police. It is possible. It will be unjust. It will be highly inequitable, right? Because you are going to punish somebody for an act which he was free to do till yesterday. That is not justified. It creates a situation where there is no assurance in the society. That is why whenever any law is made, a criminal law is made, it is applicable from the date the law is made or comes into effect. It can't be applied from back date. But other laws like tax laws, they can. So today the government can bring a tax law and can say this taxation will start from 2020 only. Or government can bring a policy, a law, and can say this scheme now starts from 2021 only. It can be done, but not criminal laws, right? Okay. No ex post facto law. Second is very, very simple. No double jeopardy. What is double jeopardy? Double punishment. See, when it comes to this idea, there is a term which this double jeopardy is also there in USA. In USA, they have the Fifth Amendment, which talks about no double jeopardy. Nobody shall be punished for the same offense more than once. Nemo debet bis vexeri. Now, maybe my pronunciation may be incorrect. The phrase means a man must not be put twice in peril for the same offense. Okay? See, you have to understand that why don't we allow for this? It's a very old US judgment, the Green case of 1957, which means that, which says that the state, the state with all its resources should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to, say, embarrassment, expense, ordeal, and also compelling the person to live in a continuing state of anxiety, insecurity, right? You don't keep on filing a case, the same case against the person. Once the court has found you not guilty, you file a new case now. Sorry. Or once the court has punished you, you can't punish the person again for the same crime. Okay, against the person for the same crime. Now, let us say you have killed somebody. The court sent you to jail for 14 years. After you come out, you again kill somebody. The nature of crime may be the same, but it's a different crime. You have killed a different person. They are two separate cases. So you'll be punished again, right? But not for the punishment that was given to you, not for the crime that you committed, say 14 years back. Again, this is available only in judicial proceedings. So think of a simple example. When in your school days, when you used to get very poor marks in your school, the teacher would thrash you. You come back home, mom would beat you. In the evening, father came home, he would treat you properly. Multiple times you're being punished again and again for the same mistake of not studying. Can you go to court and say double jeopardy? You can't. Don't try all this also, please. The court will say leave immediately. This is only meant for judicial proceedings, not administrative proceedings. So let's say you made a mistake in your company, you are involved in some corruption activity, etc. And because of that, your promotion is denied to you, not given promotion. That same logic and reasoning can be used again and again against you to keep on denying you promotions. So this is only meant for what? Judicial proceedings. Done. No double jeopardy. One simple point I'd like to mention here is some people have this belief, wrong belief, because of our great cinema industry. Not our cinema only, world over, that's the same story, because cinema is meant for general public, but this is a blatant abuse of cinema. There's a movie called Luck, starring Imran Khan, Shruti Hassan, Sanjay, Danny Denzongpa, all these people. In that movie, there's a scene. So I had no idea and no interest of watching the movie, because a lot of students would always come to me with this doubt that, sir, you are saying that no double jeopardy is there, but if somebody is hanged and the rope breaks, then what happens? The punishment is over. Now he is free to go. I would tell them, no, the CRPC does not allow for this. The old CRPC also of 1898, section 403, does not allow for all this. But they would say, no, sir, but in movie they are showing this. So I had to waste my time and watch that movie. It was a mental torture anyway, but still, things you do for polity and the students, which students don't appreciate. This was a mental trauma for me, agonizing. Anyway, so in that movie, there's an opening scene which says that Ravi Kishan, this actor, he is in jail for a very draconian crime. So what happens is that he is hanged. He is being given the death sentence. He is hanged and the rope breaks. Next scene, cut to the next scene, they show him moving out of jail, smiling happily, and there's a background voice which says he could not, the rope broke, and according to the judicial system of the country, nobody can be punished more than once. Hence the police had to let go of him. Sorry, that's not how this law functions. The CRPC very clearly says that to be hanged by the neck, clarifying, not by the leg, waist, by the neck till death. So till you die. If the rope breaks, don't worry, we'll hang you again. No problem. So this is with respect to double jeopardy. So this is the movie, the great movie called Luck. Don't watch the movie, please. It's okay. It's not worth the time. So it's not as bad as Deshdrohi, so it may not be fun also. Now the third one is no self-incrimination. So when the police arrests you, no, in the Hollywood movies they show when people are arrested and the police reads their rights. You have a right to remain silent. In India also, we have a right to remain silent. This is our right to remain silent. Right to remain silent. When the police arrests you, keep quiet. Don't say anything. You cannot be forced into being a witness against yourself. You cannot be forced into giving a testimony, evidence against yourself. It is the duty of the prosecution, the police, to establish your guilt, not your duty. Okay? innocent till proven guilty. It's the police's task to establish guilt, not your task. Let them perform their activity. You keep quiet. Are we clear on this? This is called no self-incrimination. However, if we use this, it is only meant for you not to be a witness. So the police cannot ask you to give a statement, accept your mistake. So what happens in the police lockup is the police will ask you nicely, do you accept your mistake? You say, no, I don't. It's okay. The police has no right to do anything. No right to do anything. Okay? I hope you understand. The police has no right to do anything, and the police may do something. Difference. I am not saying the police will start beating you and all. I don't know. I have no experience. So some of you are mentioning here, but sir, बहुत मारती है. So I have no idea. Maybe, please, personal experiences separate. Okay. Anyway, and also let me clarify. Any statement you give in front of police is not admissible in the court. Clear? Whatever you say, the police asks, did you commit a crime? You say, yes, I killed 100 people. Then go to court and say, what 100 people? The police was beating me. I therefore was made to say all these things. That is why the point is that the testimony given in front of police is not admissible in court. Are you clear? But yes, if you accept the mistake and you reveal some information which can be ascertained by the police, let's say you say, yes, I killed somebody and I threw the dead body in that river, and the police actually finds dead body in the river, then your statement can be used in court because you have given an information to police. Clear? Okay. But this does not mean that the police cannot ask you to submit your mobile phone, laptop, giving thumb impression, specimen signature, blood specimen. These can be given. The police can force you, come on, show me your mobile phone, give me your password. Some of you may say, it's okay, I accept my mistake, don't take my mobile phone password. Right? So that's there. But this is how this system works. You will not be forced. Otherwise, it's okay. Feel free. The police can come and search your house, try to collect evidence, but they cannot force you into accepting your mistake. This is also meant for criminal proceedings only. One more thing, Selvi, Selvi, Selvi case. In the Selvi case, this matter came to light that there is something called narco analysis, or things like lie detector test, polygraph test. Now, these are slightly more scientific tests. So, what is this narco analysis? See, in the polygraph test, the police will check your pupil dilation, heartbeat, etc., and may try to find out whether you are lying or not. Truth, the test of lie detector machine. Then narco analysis. In narco analysis, they will inject some drugs in your body, right? And sodium pentothal, etc., is injected. Don't go and purchase it in the market. Just like when you drink with your friends, etc., what happens? Two things happen when you drink. One, you start blurting out truth. Second, you start speaking in English immediately. Right? That English comes out naturally. So the logic of this is what? When you drink too much, you lose control over your nervous system. Then you cannot keep a check on yourself. Similarly, when you inject drugs like these under narco analysis, the person loses the grip and control over himself or herself, and possibly can reveal some information. But these things can only be conducted with permission of the accused. Without their permission, you cannot conduct all these tests. Clear? That's it. Article 20 done. Now coming to Article 21, the most important right. The words are very small, very limited, 25-30 words only in total, but the largest ramification, the widest possible interpretation is of this right only. This is the protection of life and personal liberty. This right is never taken away. Even during emergency, you will always have the right to life and liberty. So, no person shall be deprived of his life or liberty except according to procedure established by law. Without following a procedure, without following a procedure, your right to life or liberty will not be taken away. Okay, so what is this procedure that we are talking about? Procedure established by law. This is a concept which is borrowed from Japan. What does this mean? The procedure mentioned in the laws must be followed. Tell me, what is the first step in the criminal procedure system? What's your first task as a government official, as a policeman, as an executive? First task in situations: FIR, charge sheet, investigation. Sir, first task is to prevent a crime. So angry people. Directly arrest. Calm down. Firstly, prevent a crime. Tell people don't commit crime. That's the first step. Some of you are going to be dangerous IPS officers. Prevent a crime. Now a crime has been committed. Okay. Then preliminary inquiry. You have to firstly conduct inquiry. Okay. Inquire about the complaint that you receive of the crime being committed. Next step would be you can make some arrests, file an FIR. Arrests can be made, possibly if required. Further investigations can be done. Next step will be what? Then you go to the court, file a charge sheet in the court. I am giving a very generic step by step procedure. Okay. Then in the court also, trial takes place. Yes or no? Trial takes place. Where what happens? Finally, the verdict comes. In the court also, if you cannot get a lawyer, the government provides a lawyer for you. They take a lawyer. The verdict comes, and based on if you are if you are not guilty, then you are acquitted. And if you are if you are actually guilty, then you are convicted. And once you are convicted, it can result in fine, jail, or both. This is the entire criminal justice system. Now, in some laws, no inquiry, direct arrests, all these things are there. It can keep on changing. But the point is, this process is always followed. This procedure must always be followed. You can never violate this procedure. Are we clear on this? So, procedure must be followed. As we say, apply the laws in a fair manner. Don't go for arbitrary action. Who is applying the law here? Executive. Executive action cannot be arbitrary. So, procedure established by law, it keeps a check on arbitrary executive action. Clear? Okay. Yes, Kishan, that is also there. Everybody knows this. We'll study Article 22. Why to impress me? It's okay. I understand it. You have to be taken to court within 24 hours. Then the court will further grant you either bail or send you to further police remand. That's all there. Ignore it. Now the point is that its process is followed properly. That is called procedure established by law. Now please tell me something. When this process is followed, you are applying the law properly. But will justice be done by this? What if the law itself is wrong? What if there's a law that anybody wearing dress like this, if you are found wearing a dress like this, you will be jailed for 10 years. Let's say this is a law. Damage to Eyes Act 2023 is passed. Anybody found wearing a dress like this, sorry, will be jailed for 10 years. This is a law. Now, the procedure starts. We'll tell people, don't wear a dress like this. If you wear a dress, inquiry is conducted against you. Arrests are made, FIR, investigation, evidence is found, you are taken to court, in the court evidence is presented, the entire procedure could be followed. But my point is, what's the problem? If somebody wants to wear a dress like this actor is known to wear these kind of dresses, or sometimes known to wear no dress at all. So the point is, it's your life. If there is a law like this, will the law be fair? Tell me. Will the law be fair? The law is not fair. It's a stupid law. Always remember, the law must be fair, the law must be just, the law must be reasonable, the law must be rational. These are very, very important elements. The law cannot be manifestly arbitrary and random, right? So, not only should the law be applied properly, the law in itself should be fair. Now, tell me, who makes the laws? Made by Parliament? This means that we have to follow due process. Legislative actions cannot be arbitrary. So, due process of law, which is borrowed from USA, it places limitation on the legislature. That legislature always ensure that justice is very important and it should be done fairly. Fairness of law is important. Law should be applied properly. Very good. But the law in itself, what you are applying properly, should also be proper. Are we clear on this? Think of it. Procedure established is a process you do. Let's say you fall sick. When you fall sick, you eat a medicine. If you have headache, if you have headache and you take a medicine, but the medicine is for loose motions, then is the medicine correct? Of course not. You are following the procedure of if you have headache, you go to a cancer specialist. You follow the procedure that I have headache, I have some disease, I am going to doctor. But did you go to the right doctor? Do you take the right medicine? I am following the law, but are you applying the right law? So mere application of law is not sufficient. You also have to see whether the law is logical or not. So due process, which was not a part in our country under Article 21, became a part since 1978. In this judgment, Supreme Court said that not only are we going to check whether the law is applied properly, we'll also check whether we will also check whether the law in itself is fair or not. Because in the AK Gopalan case, Supreme Court said that it is not our concern. Law will be fair. Our task is to only check whether the executive implemented the law properly or not, whether there was fair application of law or not. Whether the law is right or wrong, that we can't check. But in 1978, Supreme Court had a change of heart. It said no, due process must be followed, meaning the law has to be fair, justice has to be provided. That will only come when the when the law is fair, just, reasonable, rational, free from any kind of stupidity. I hope this point is clear. Everyone? So even though it is not mentioned in the constitution, still this now includes due process. And let me also clarify one thing here. This Article 21 is not just right to life. Don't have this misconception. Oh, living, that's it. I am merely surviving, sufficient. No, 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 no. It is way beyond survival. Supreme Court in various cases has read into this right, widening the scope of this right. Right to life and dignity also involves right to live with dignity, right to decent environment, right to livelihood, right to privacy. A very famous 9-judge bench, retired Justice Putta Swamy case of 2017, where Supreme Court said everyone has a right to privacy. Srimant, due process means double check. Don't create definitions on your own. I'm telling you, due process means the law is fair, just, and moral. That's it. Okay. Then, right to shelter. So many rights. Right to health, right to free education, right against solitary confinement. Remember the Shatrughan Chauhan case of 2014, right against solitary confinement. Then right to speedy trial, right against handcuffing, right to timely medical treatment, right of prisoners to have necessities of life, right of women to be treated with decency. So many rights are there now. Right against public hanging, right against inhuman treatment, right to travel abroad. This was the Menka Gandhi case actually, when her passport was impounded. Right? These rights are not written in the constitution. They are just interpretation of Supreme Court. Supreme Court cannot make any changes in the constitution, but it can interpret the constitution. Just like collegium judgment is not written in the constitution, but it is the one which is used. Similarly, these rights are not mentioned, but they are the ones in use. Okay. Right against bar fetters. What is a bar fetter? This is bar fetter. When your legs and hands are attached to bars. Sometimes they are called crossbar fetters. This is a classic example of a bar fetter. Or this is a chain fetter. When your legs or hands are attached with a chain. So these things are not allowed. Okay. Right to sleep, which some of you do a lot in the class, morning bath especially. Right? Sleeping nicely. away from the observation of the teacher and the parents, full enjoyment of right to sleep. I think some of you will appreciate it. Oh, sorry, they are sleeping. How will they appreciate it? Others, right to electricity is also there. Right to marriage. This was the Hadia case of 2018. So, right to marriage. Now, please, right to marriage does not mean marry anyone. Right to marry somebody of your own choice, subject to the condition that they should also marry you. Are you clear? Then, right to freedom from noise pollution, right against sexual harassment, all these things. Right to electric supply. So everybody has a fundamental right to electricity. Of course, these are all subject to the state's capacity to provide for electricity. Don't go and claim I want free electricity. That can't be there. If the state has provided you, then it has to provide to everybody. Payment will be made. Nothing is free. Don't think it's free. Okay, that's it. Solve this question. Came in 2021. What's the answer? I launch a poll for 15 seconds. Please mark your answer. Some of you marked Article 19. Right to privacy is Article 21. We just explained it right now. Solve this question. Let's see if you can get more than 95% plus correct answers or not. Or is that just a dream harbored by every faculty? %89. B is the right answer. Solve this question. I'll give you 30 seconds. Oh, great. 93. We have crossed 90, I think, for the first time ever. So, C, Article 20. Look at this repetition of questions. Article 21, right to privacy, asked in 2018, again asked in 21. Right? That's it. We are done with Article 21. Last is Article 21, capital A, right to education. Very simple. In 2002, with the 86th Amendment Act, we inserted Article 21, capital A, as a fundamental right, which is what? The state shall provide free and compulsory education to all children of the age of 6 to 14 years. So the age band of 6 to 14, you will get free and compulsory education. How? In such a manner as the state may by law determine. Again, you get education, go and enjoy education, but where? School. So state says we'll make a law and we'll determine what will be the parameter. Again, an example of non self executory right, and this has been done. This is the law. In pursuance of this right, the RTE Act, Right of Children to Free and Compulsory Education Act 2009 has been passed. Clear? This is Article 21, capital A, right to education. Now, very important, this 86th Amendment Act actually made three changes. Change number one was that it added Article 21, capital A. Change number one, right to education. Change number two was that it added or it modified Article 45 in the DPSPs. So when you study DPSPs, you'll come to know that through the 86th Amendment Act, the words of DPSP were changed. Now, the DPSP mentions that the state shall endeavor to provide ECCE, Early Childhood Care and Education, for all children until they complete the age of 6 years. And lastly, the same 86th Amendment Act also made a change, also added one fundamental duty, Clause K. It shall be the duty of every citizen of India who is a parent or a guardian to provide opportunities for education to his child, or as the case may be, the ward between the age of 6 and 14 years. Fundamental duty as well. Three changes made with one modification that was done in 2002, the 86th Amendment Act of 2002. That's it. We are done with the class for the day. That's all from you guys. Jai Hind. And in case we want to revise and study, let me use the last slide only. So we'll be focusing on what? The monthly magazine for the month of June, Yojana Kurukshetra, July. The revision for the PPT is very, very important. Political theory, last week of political theory, we should be revising it now. The third time, it should be over. Then your typical reading of the editorials, and please attempt the PYQ that we saw today. Write the answer and send the answer as well. Okay, that's it. That is all as far as our task for tomorrow is concerned. And no, Shargun, we did not mug up all these rights. Gayatri, scandalize means to shock, to horrify. That's the meaning of scandalize. Surya, leaderboard. Okay, leaderboard. Show the leaderboard. Shamil, Janvi, and Kishan. Oh, we saw a lot of questions from Kishan and Shamil today. Janvi, not so much. Then Ankur, Neeraj, Architas, Satyaprasad, Aishwarya, Meera, Abhishek, and Hilo. Funny, Sumant, Sachin, Galaxy World. What is your name, Galaxy World? Geetikon, Surya, Twisha, Piyush, Sudarshan, Preksha, etc. getting 7 correct. Mir Shabir, read the articles that I tell you from the Bare Acts. That's how you read it. That's it. Surya is criticizing the court say in a religious matter Sabrimala case. It can be if you don't make any personal remarks on the judge's biasness, then that's fair criticism. Yes, Chandra Jyoti, it has got no relationship to your graduation. Frankly, you can score very good marks. Srimant, revise the slides again and again and again and again and again. Keep on reading it. Keep on reading the slides. Solve MCQs. Go online, search for polity MCQs and solve them as many as you can. Again revise, again solve. Ankush Chand. Okay. Shivani, sedition law was there in Pakistan. It has been declared unconstitutional now. Vivek, if you attended the first class, you would know that you can Google search for all these things. Google search for the copy. Right? Constitution of India PDF. The first link you will get is the legislative.gov.in. Download from there. No, Kishan, right to life does not include right to die. Okay, euthanasia means somebody's life is taken away because to end the suffering. So in our country, passive euthanasia is allowed only under the strict guidance and control of the judiciary and three medical practitioners. Passive only. Zonal council, Telangana is included in the zonal council. Puja revision. Sachin, Navam, Rebia cases of no concern to us. Anyway, the matter is pending in the court now. When the judgment comes, you'll get to know. Rashida, what's the doubt? Sejal, mains examination difficult. In prelims, they can come. Day after tomorrow is the last class, not tomorrow. Passive euthanasia. So, Puja, passive euthanasia refers to death through omission. No, when somebody is in on a deathbed, suffering in the hospital, and is on a life support, you end the life support. That is called passive euthanasia. Ocean, that is with respect to the CSAT marks or CSAT paper being very tough. Vejshri, as of now, I don't think so. Puja, Telangana along with Andhra Pradesh, right? Kirti, there is no such optional subject as polity. Maruti, this means that you have not attended the first week Friday class of answer writing discussion. Please watch that video to get clarity on this question. Shamil, yes, Menga Gandhi case is very important, so year is also important. It would be better. Prashik, it's better to read it separately. It has got way more detailed information. No ex post facto law. Laws cannot be applied from backdate. So if let's assume that for pickpocketing, the punishment is 2 years in jail maximum. But today, I say for pickpocketing, the punishment is death sentence. And this punishment will now be applicable from 1950. So all those people who had been earlier held for pickpocketing and have also been let off by the courts now after punishment, come back, we'll kill you. That will not be allowed. No, Dhyaneshwar, don't worry. Just the rights are left. DPSP is a small topic. Then we have a topic called fundamental duties, which is a 10-minute topic. Then we have Schedule 8 languages, which is again a 5-minute topic. Then we'll discuss the preamble and we are done, which may be a half an hour topic. So what remains is not a very big topic. Okay? No, Pooja, you can skip that. Sanctions are important. I'm not sure what is that. UCC discussion will take place under DPSP's Article 44. Hopefully tomorrow or maybe in the first hour of day after tomorrow. Shrimant, I have told you those articles which are important. Read those articles. I have explained the context of the article, right? So I think the meaning is known to you. It's mentioned there as a language. So you can understand the language also now. And the more you practice, the more you read, the better you get at understanding also. Okay. That's it. Yes, Anchal, these are relevant questions. Yes, Mangla, That could be a very logical optional without doubt. Alina, include all of them. No problem. Anshu, download the notification and verify from there. Ocean, what kind of statement is this? Independent MP cannot join any political party. Before the election, you are not an MP. So why are you calling yourself an MP? Before the election, you can join any party you want. Okay, guys, that's it. That's all for me for today. Let's meet tomorrow. Please revise, study, and tomorrow we'll continue our discussion on some other rights, the remaining rights largely, and then DPSPs. Till then, that's all for me. Jai Hind.